So, shall we begin? Okay.
Yes.
A very good evening to one and all. I am Sumedha, joined by my colleague Harshita from Foundation for Democratic Reforms. Welcome to session 3 of this edition of the Indian Democracy at Work conference on the theme Rule of Law. The primary components of a criminal justice system are police, prosecution, judiciary, and prisons. In the preceding 3 sessions of the conference, we have explored in great detail the challenges and necessary reforms, structural and otherwise, in respect of the police and prosecution. Procedural law, which governs the functioning of all of these components, however, plays a vital role in their overall efficacy and effectiveness. Centered on the topic of criminal procedural reforms, the aim of this session is to identify the drawbacks in the current framework and to arrive at plausible solutions. I take immense pleasure in introducing the eminent panel of experts we have with us today. First, we have the chair for the session, Shri P.S. Ramohan Rao. He is a former governor of the state of Tamil Nadu. He has also been the Director General of Police, Andhra Pradesh. He was conferred with the Indian Police Medal in 1974 and the President's Police Medal in 1982. We welcome you, sir. Next, we have with us Shri G. Kishan Reddy, the Minister of State for Home Affairs. He has been the BJP State President of Telangana and subsequently also served as the floor leader of the BJP in the Telangana Legislative Assembly. We welcome you, sir. We also have Professor Dr. Ranveer Singh, who has been the founder Vice Chancellor for NLU Delhi from 2008 to 2020. He has also been the founder Vice Chancellor of NALSA, University of Law, Hyderabad. Professor Singh served as the chairperson of the Committee for Reforms in Criminal Laws, recently constituted by the Union Home Ministry. He was also a member of the Soli Sorabji Committee on Police Reforms. We welcome you, sir. Finally, we have Dr. M.R. Ahmed, former Inspector General of Prisons, Andhra Pradesh, and former Director of Academy of Prisons and Correctional Administration, Vellore. He was a consultant to the Bureau of Police Research and Development and Penal Reform and Justice Association. He is also a recipient of the President's Distinguished Service Medal, Correctional Service. We welcome you, sir. The session will begin with a 5-minute presentation from the Foundation for Democratic Reforms. The chair for the session will present his views for 10 to 12 minutes. The chair will then call upon each speaker, who will also have 10 to 12 minutes to share their insights. Post that, the chair may open the session for a panel discussion. The last 30 to 45 minutes will be dedicated to taking questions from the audience. We request the participants to keep the questions brief and lucid and also mention the panelists that they would like the question to be directed to. If there are any technical glitches, be assured that they'll be resolved as soon as possible. Thank you for tuning in, and I hope all of you will find the session engaging. I now invite my colleague Harshita to give us a short presentation on the agenda for this session.
Thank you, Sumedha. At the outset, thank you to each of our panelists for taking out time from your busy schedules and agreeing to enrich this crucial discussion. Thank you also to all the participants for joining us, and we hope you find this session informative. Let's start with the presentation. The importance of a sound procedural framework cannot be overstated. It is the basis on which our police, prosecution, and courts function. Yet, our primary criminal procedural law, the CRPC, has been unable to adapt to the rapidly changing socio-economic conditions and evolving nature of crimes. It is in this context that I would like to briefly draw attention to 3 sets of numbers. Let's start by looking at figure 1 in the presentation. According to it, there are 27 million criminal cases that are pending before just the subordinate courts. And out of this, nearly 80% have been pending for more than 1 year, which indicates that there are inordinate delays in the trial process. Let's move to figure 2. 330,000. That's the number of under trials currently making up about 70% of the prison population in India. If you want to get a sense of how alarming this number is, then you must know that there are only 14 countries in this world that have a higher share of under-trial prisoners. Figure 3 also presents a similar picture where the conviction rate for all IPC crimes is nearly 50%. In contrast, some developed countries have twice the conviction rate for criminal offenses. These failings have been attributed to the CRPC's archaic and complex provisions. Now, back in 2003, the Malimat Committee recommended several amendments to the CRPC with the broad aim of revamping the criminal justice system. In addition to the Malimat Committee, we have the Soli Sorabji Committee in 2005, the NR Madhav Menon Committee in 2007, and most recently, 2020, the Committee for Reforms in Criminal Laws, constituted by the Union Home Ministry, of which Dr. Ranbir Singh, one of our panelists today, has been a chairperson. Therefore, the problem of India's procedural complexity has long been recognized, but very little has been implemented. Let us now look at some of the major issues identified by the Malimat Committee and corresponding recommendations. First, nature of a trial system. In the adversarial system currently followed in India, the judge is limited to examining witnesses submitted by the parties and evidence already on record. This impedes the judge from being able to rectify shoddy investigation and prosecution. So, is it time we placed a statutory duty on the judge to play a more proactive role in the trial? Second, standard of proof. Beyond reasonable doubt, not all criminal offenses need to be or even can be proved on the standard. With newer and more sophisticated forms of crimes and unreliable witness testimony, securing evidence of such high standard all times has increasingly become a challenge. Thus, undoubtedly, we need to revisit the criminal standard of proof and design a standard that not only protects the innocent, but also ensures the guilty are punished. Third, confessions. Most of the rules for collection and admission of evidence is contained in the Indian Evidence Act. Section 25 of this Act renders inadmissible any confession made to a police officer irrespective of rank. This provision deprives the police of a critical piece of evidence. India already has various laws that allow confessions to be recorded by the investigating officer beyond a certain rank. Why can't we extend the system to all crimes? The next issue is perjury. This is a growing menace, and anti-perjury provisions cannot be effectively enforced if the trial process is cumbersome, like the one prescribed in Section 340 of CRPC. The unfortunate end result is hostile witnesses and false evidence. If speedy justice is an aim, one wonders why a summary trial is not the norm for perjury cases. The CRPC already provides for swift disposal of cases. It is just a matter of implementing these provisions. Next, under trials problem and the alternatives to imprisonment. There is increasing realization that not all convicts require imprisonment, either due to the nature of their crime or their propensity to commit crime. Thus, there is an urgent need to find suitable alternatives to imprisonment, such as community service, confiscation of property, probation, or any of the alternatives that will be discussed today. These would help alleviate the problem of under trials in our jails. With this, we conclude the presentation. We now have Mr. Ram Mohan Rao, who is the chair for the session. I request Mr. Rao to give the introductory remarks and steer the discussion from this point.
I welcome the participants to this digital conversation on criminal procedure reforms, procedure trial reforms. Particularly Dr. Ranbir Singh, who has a wealth of experience in this subject, and also Dr. Ahmed. I'm also happy that Jayaprakash Narayan is participating in the discussion. Particularly, I welcome the Minister of State for Home Affairs, Government of India, G. Kishan Reddy, who will be presenting his side of the problem shortly. India, after 70 years of independence, India remains a poor country. Though there is great deal of satisfaction recently that India is becoming the third largest economy in the world. That is only in terms of the absolute aggregate domestic product, GDP, gross domestic product. But if you take the per capita GDP, India remains still one of the poorest countries, probably in the lower half of the Committee of the Nations. Therefore, there are many reasons for this backwardness, continued backwardness, after 70 years of independence. Low productivity of human beings, then policies, economic policies not suited to growth, not suited to rapid growth, and like that. But one particular reason why India is so backward is that we don't have rule of law. Rule of law is a very essential precondition for any democracy, or for that matter, any society, for survival and success, and for attaining prosperity. Unfortunately, in India, rule of law has been a serious casualty over the years. And if anything, the position has only been deteriorating and not improving. And there are many reasons for this slack rule of law in India. And one of the reasons is our criminal justice system. Now, as all of us know, the overarching framework for the rule of law consists of the tripod of the police, the prosecution, and the judiciary, the magistracy, in regard to the criminal justice system. Now, I think this conference has already separately dealt with the issues touching the police and the prosecution. And this session is mainly devoted to the criminal justice system, and particularly what role the criminal procedures play in the speedy, effective, and humane dispensation of criminal justice. Now, criminal justice system is essentially governed by the Indian Police Act, the Indian Penal Code, and a whole bunch of subsidiary laws, penal laws, the Indian Evidence Act, and the Criminal Procedure Code. These three essentially, these constitute the tripod of the criminal justice system, the framework, of which the Indian Evidence Act and the Criminal Procedure Code are very important from any angle. Now, unfortunately, Indian Penal Code, Criminal Procedure Code, and the Indian Evidence Act, which were framed in the middle half of the 19th century, still rule the roost essentially. Society has enormously transformed in the last 200 years. Now, in fact, today's society, anywhere in the world, in any country, bears no resemblance whatsoever to what existed in 1830 or 1860 or 1880, when these important laws were enacted by the then colonial government. You take a look at education, look at healthcare, look at physical mobility, you look at communications, you look at the economic situation, industrialization, modernization. Society has tremendously transformed in the last 200 years, but not much has been done to change these three principal criminal enactments, legal enactments, to adapt to current situation and current conditions. That is one important feature of our existing criminal justice system. Our criminal justice system is based on laws which are outdated, which are antiquated, and which have no relation whatsoever to the present day conditions and the present day situation, whether it is society or the economy or governance. Take whichever branch of government you take, they bear no relationship at all. So there is an urgent need for us to look at these laws and bring about the necessary changes in these laws in order that the rule of law, particularly in relation to public order and peace, criminal law, rule of law is brought up to date, up to speed, and reflect the existing situation and conditions of the society. In this regard, there is one very distinguishing feature of the Indian criminal justice system, and that is the distrust of the police. In fact, your entire Criminal Procedure Code and Indian Evidence Act are based on complete distrust of the police and their ability to bring offenders to book. The overall impression, the popular impression, not only the popular impression, but even the impression in the circles of government, in the circles of judiciary is that police frame cases, they bring false evidence to courts, etc., etc. And therefore, all the criminal procedure should aim at eliminating the danger of the consequences of falsification of evidence and bringing innocent offenders to the book and presenting them before the criminal courts. If you look at the police, in fact, there has been a lot of reform in the police, though the reform may not be adequate, may not be sufficient. I'm sure in the earlier sessions, they must have devoted enough attention to this aspect of police reform. Now, with regard to the criminal procedure reform, which is very essential if we have to improve the rule of law with reference to peace and public order, we find that successive law commissions have not paid much attention to this aspect of criminal procedure reform. In fact, in the paper that has been circulated, you will notice that most of the recommendations with regard to reform of criminal procedure, Indian Evidence Act, and etc. have been made by agencies by organizations other than the law commissions. It's a very notable feature of what has happened over the last 70 years. Now, more recently, in 2002, I think, late 2001, early 2002, the NDA government under the leadership of Atal Bihari Vajpayee constituted a committee for looking into criminal justice reforms and making recommendations. This committee was headed by Justice Malimat. And Justice Malimat committee produced a very valuable report in 2003, making a series of reforms which may not be comprehensive, but they represent a significant advance in the effort and endeavor to change our criminal procedure over the years. Unfortunately, this has remained on the shelf for the last 18, 19 years. And thereafter, the second Administrative Reforms Commission, of which Dr. Jayaprakash Narayan was also a member, made also some very valuable and significant recommendations with regard to speeding up the dispensation of criminal justice. And those also have remained on the shelf. And in this background, I suppose, this conference aimed at improving the rule of law by a series of recommendations with reference to the police, with reference to the prosecution, and with reference to the magistracy, that is the judiciary, is very timely and also of great importance. Now, Manimat Committee made a few recommendations which are very significant and which are seminal. Now, because of our colonial heritage, we have a criminal justice system which is based on adversarial law, in the sense that criminal cases, criminal prosecutions against offenders, whether they are property offenders or offenders against body or economic offenders, our criminal justice system envisages that the case against the offenders should be proved beyond all reasonable doubt of an ordinary prudent man or prudent person. This raises the bar of the standard of proof to enormous proportions. That is one aspect. The other aspect is that in the adversarial form of justice, the responsibility to prove the guilt of the offender completely rests with the prosecution. The judge plays no role in this. It is a contention between the prosecution and the defense. And in that contention, if the prosecution is not able to prove the case beyond all shadow of doubt of an ordinary and prudent person, then the offender gets acquitted. This is the principle of jurisprudence that entirely governs our criminal justice system. And there is a corollary to this principle of jurisprudence. And that corollary is, in fact, there is another principle. And that principle says, let 100 guilty escape punishment so that not a single innocent person is convicted in court. Now, this leads to hundreds of offenders who are really guilty getting away with what they have done, so that we ensure that no innocent person is ever convicted. And I'm not very sure that innocent persons are not convicted in this whole system. Though I may tell out of my own experience, I may assert and in fact claim out of my own experience that it is very seldom that innocent persons are implicated in criminal cases by the police. And those exceptions are generally when there is tremendous public pressure to detect a crime and to bring the offender to justice, as a result of which some deviant police officers implicate innocent persons so that they can get away from the public pressure. Even so, innocent persons do get convicted, but preponderant number of guilty persons escape conviction because of the very, very high and almost impossible standard of proof. And in this regard also, Justice Malimat Committee have made some salutary reforms. And another feature of our criminal procedure which makes trials protracted and delayed relates to the presence of the accused in court at the time of trial. Cases are adjourned for dozens of times, for years together, to ensure that all the accused are present in the court at the time of trial and when evidence is collected. The, the offenders, the accused persons, are represented by the lawyer, and in spite of that, unless the accused are present in court of law, no case ever commences for trial. And this results in delay of years and years and years. Now, if there are 10 accused, they ensure that one accused is absent on each date of hearing by rotation. With the result, you will have 10 adjournments. And then the cycle repeats itself. And this is one of the reasons that cases are protracted. These are some of the features of our criminal procedure which makes our system, our criminal justice system, hopelessly dilatory and in fact defeats the very ends of justice. Now, I would now, with these remarks, throw open the subject for the views of our other panelists, the Honorable Minister of State for Home, and then Dr. Ranbir Singh and Dr. M.R. Ahmed. Thank you very much. Now I request, if the Minister of State for Home is available, I would request him to present his viewpoints in this regard.
Yes, sir. Sir, give us a couple of seconds. He will be joining us.
Dr. Ranbir Singh, welcome to you. Pleasure meeting you after a long time.
Not able to hear Dr. I leave the floor open to Sri Krishan Reddy, our Minister.
Respected Sri P.S. Rammohan Rao Garu, former Governor Tamil Nadu, respected Dr. M.R. Ahmed Garu, Dr. Ranbir Singh Garu, Dr. Jayaprakash Narayan Garu, participants in this virtual conference, and friends from media, good evening to you all. At the outset, I congratulate the Foundation for Democratic Reforms and its chief mentor, Sri Jayaprakash Narayan Garu, for organizing this conference on Indian democracy at work. I am aware this conference is being in collaboration with the Indian School of Business, ISB, and the University of Hyderabad. The theme is Rule of Law. Dr. Jayaprakash Narayan Garu has been working with missionary zeal for reforms in democratic polity for a long time, and we should appreciate his sincere, dedicated, hard work to strengthen democracy in India. The Indian society, from times immemorial, has been guided by the principles of Dharma, Dharma Rakshito Rakshitam, which means those who protect the Dharma are protected by the Dharma. This has been the guiding principle of our ancient lawmakers and law enforcers. Today, we are also discussing criminal procedural reforms. I wish to inform this conference that our Home Ministry has already constituted a 5-member committee for reforms in IPC CRPC laws in May 2020 to examine the Indian Penal Code 1860, the Code of Criminal Procedure 1973, and the Indian Evidence Act 1872 for possible reforms. The need for reform, of course, is mandated by the changing times and the changing nature of crimes. The world is changing at the fastest pace. So far, the crimes modus operandi is becoming much more sophisticated than even before. Further, globalization has taken crime beyond the frontiers. There is no second opinion that existing IPC, CRPC, criminal procedures need reforms to ensure that criminals are brought to the justice fast and victims are amply protected. Currently, our criminal justice system faces following major challenges: huge pendency of cases, lack of transparency, cumbersome procedures, lack of professional human resources. One of the serious concerns, the delivery of the justice is criminal cases today is inherent delay. In the virtual conference presentation before, Harshita has given detailed presentation, and the chairman, respected Raman Rao Garu, also in detail, he also spoken. Friends, it is said that justice delayed is justice denied. It has been reported that more than 50% of detainees, and in some countries more than 70% are pre-trial detainees. Whether it is a true that no innocent be punished, it is also important to deliver speedy justice. It is pertinent to mention here that the ideal criminal justice system should not only focus on proper direction and timely investigation of the crime, but it should also have a robust deterrent mechanism inherent in it, which should be instrumental in reducing the crime rate. Secondly, the present system of criminal procedure is a crime-centric. It is also important as a justice. Malimat Committee recommended in 2003 to include victim orientation in criminal jurisprudence. I personally feel that at least in select cases, victims must get adequate compensation. One of the critical areas which cause delay is inadequate infrastructure, which help in faster investigation. We need to have more forensic labs, including cyber forensic labs. Our government has specially focused in these areas, for they play a critical role providing evidence, which is a vital in criminal trial with a scientific way. Further, the police burdened with multiple responsibilities, which very often hamper speedy investigation. We must have dedicated team of police forces exclusively for the investigation, and we must step up recruitment here. As far as criminal procedure reforms are concerned, the government under the leadership of our Prime Minister Narendra Modi ji has a very clear vision that it needs to be participate exercise involving all stakeholders across the spectrum of life. A major overhaul of our law is required. The overhauling should be not only restricted by formulating new laws, but should also be focused on repealing the outdated ones and making the laws simple. The vacancies need to be filled at the earliest. New posts have to be identified and created. The recruitment process for the judges also needs to be revamped so that the bright and talented youth should opt for the judiciary first option. We also need to focus on reforms of all components of the criminal justice system, police reforms and prison reforms. Diverse a special mention and attention in this regard. As the Honorable Prime Minister has himself stated that the government is making various efforts for enhancing cloud-based infrastructure and will enhance ease of justice for the people of India. The new structure and content of criminal laws will have citizens and their interest at its core. It will be a tune with evolving society and modern democratic values. Our government is committed reforms. You are aware, we brought in Tribal Talaq Act, POSCO Act, cyber security laws, and forensic science laws, women safety, safe city projects, and many more, which shows our resolve. The 5-member committee, which I mentioned on IPC CRPC, has started seeking views of different aspects, and they are going to move all important cities and capitals of the state to take opinion from the stakeholders, and Government of India going to organize seminars in all law colleges, universities with the stakeholders. I would urge all the intellectuals present here and through you, the people of India, to participate in this consultative process in large numbers. Everyone, views will matter and will help bring in the historic changes. Our Prime Minister dreams of building Atmanirbhar Bharat would be fulfilled only when we are work collectively to build a crime-free India, where police will have minimum role and the real Atmanirbharata. I thank you all for your time and patience, and personally, I thank respected Jayaprakash Narayan ji is given this opportunity to participate in this conference. Thank you everybody. Jai Hind.
Thank you, Kishan Reddy Garu. The minister cannot hear us.
Thank you, Mr. Minister, for your valuable message and indication of things to come. We are very grateful to you for having spared the time, communicated this message. I think I would now request Dr. M.R. Ahmad to present his viewpoint so that I can give continuous and uninterrupted time to Dr. Ranbir Singh, who is really the expert on this subject, so that we can have an uninterrupted discussion on the various issues that have come up and are likely to come up in the course of this seminar. I request Dr. Ahmed, particularly with regard to the under trial prisoners, and what kind of classification is done of these under trial prisoners. Because I have a feeling that property offenders, that is thieves and robbers and dacoits, they constitute a very significant portion of the under trials in prison. I would like Dr. Ahmad to give his viewpoints now.
Thank you, sir. Thank you, esteemed chair and esteemed speakers of this meeting. Indeed, it's a privilege to participate in this meeting. I will start with what Nelson Mandela has observed about prisons. It is said that no one truly knows a nation until one has been inside its jails. A nation should not be judged by how it treats its highest citizens, but its lowest citizen. Another criminologist said that if you want to see the culture and civilization of a country, go and peep inside the jail. Hate the sin and not the sinner.
The toilets.
That's what our Mahatma Gandhiji has said. Gandhiji also said that crime is the outcome of a diseased mind, and jail must have an environment of hospital for treatment and care. Prisons is a state subject under the state list of 7th schedule of the Constitution. Sir?
Sorry to interrupt, Dr. Ahmad. I would like you to focus on under trial prisoners, because that is the part of the criminal procedure reform.
Right, sir.
Instead of going on prison reform.
Right, sir. One of the major issues facing the prison administration today is the first and foremost overcrowding. Of course, I will say that apart from the overcrowding, you have prolonged detention of under trials, unsatisfactory living conditions, lack of treatment programs, indifferent and inhuman attitude of the staff, inadequate health care, mental health, staff shortage and poor training, and non-availability of timely and quality legal aid, absence of rehabilitation, and lack of oversight. I will start with, the most important aspect of this conference, this overcrowding. Now, the overcrowding, why overcrowding is taking place? Certain things we have to remember. Too many unnecessary and indiscriminate arrests, and criminalizing some aberrant behavior that could and should be addressed in social domain, a slow judicial process and a general lack of awareness relating to the process, prison as a first choice rather than last, especially for minor offenses, few, if any, alternatives to imprisonment receiving attention, minimal use of other sentencing options than imprisonment. I will give some statistics about the overcrowding. Of course, the capacity we have in our country is 4,03,739. Actually, is about 4,78,000. The number of under trial prisoners who are confined in our prisons as on December 31st, 2019 is 3,30,487. 87, which constitute about 69.05%, which percentage is considered as very, very high. And this overcrowding and a large percentage of under trials is not a recent phenomena. It has been continuing since the last 10-15 years. Now, if we look into the composition of these under trial prisoners, the under trial prisoners, out of all the under trial prisoners, 63.7% under trial prisoners are involved in offences against the human body, and 28.1% offenders are involved in property offences. So the rest of the percentage goes to minor offenders. So we have quite a large number of property offenders, and also of course, the highest number is against this thing. Now, if we look into the composition of under trial prisoners and how their period of stay is depicted, the under trial prisoners confined up to 1 year constitute about 74.08%, and up to 3 months is about 36.999%. Of course, there are under trial prisoners who are languishing in jail for more than 5 years, that constitute only 1.52, and 3 to 5 years about 4.25, and 2 to 3 years about 6.7, and 1 to 2 years 13.5. So we have this under trial problem. This under trial problem leads to so many issues. First and foremost, due to lack of accommodation, it leads to so many other issues, like first of all, the human rights issues and the stress and the strain on the part of the prison staff, and every aspect of prison administration is affected due to overcrowding. Unfortunately, though India universally accepts the philosophy that the imprisonment is for reformation and rehabilitation, but unfortunately, due to large number of prisoners, we are unable to concentrate on this aspect. Now, a goal, reformative and rehabilitative goal, could be achieved only if incarceration motivates and prepares the offender for a law-abiding and self-supporting life after the release. Now, in central jails, sir. Yes,
I would like you to focus on the under trials. Now, can you make some recommendations on how we can reduce the number of under trials in prisons?
Oh, yes, sir. Sure. Now, of course, first of all, we must concentrate more on non-custodial measures. The non-custodial measures, unfortunately, in India, we have not given much thought to it, except in minor cases or police traffic cases, where many traffic offenders are let off by fine or sometimes on bail at the police level. But all over the world, alternatives are gaining a lot of attention, and we have alternatives at pre-trial stage, sentencing stage, and post-judicial. But since we are talking about under trial prisoners, for under trial prisoners, we have pre-trial stage, we have alternatives like diversion from the judiciary, and then we have fines. We can release prisoners who are involved in minor offences and non-serious offences by fines. And we have, of course, bail provision. And then we have a system of releasing prisoners on personal bonds, and we can impose what is called house arrest by way of electronic monitoring. In many countries, especially US and Europe, electronic monitoring has become very popular. Offenders who are not threat to society and who could be safely kept outside the jail can be monitored through DFID system, electronic monitoring, which I think India should start implementing soon. And as far as, since sir has asked me to only tackle about under trial prisoners, and we need to first of all see whether the person who is arrested, whether he is a threat to society, whether there is a need, any need to keep him in prison, because prison can never be a good place. Prison is a bad place. This is a fact. Any amount of facilities you give, prison continues to be a bad place. We think that by bringing a person, arresting and bringing him to prison from a place called society where positive vibes prevail, and then putting him in a place called jail where negative vibes prevail, and we consider that jail is a place for reformation. But jail is a very, very bad place. It damages people. In fact, it stamps an individual, and not only that, the process called imprisonization is very, very dangerous. The contamination that takes place in the jail cannot be described, and we know that number of in fact, Justice Venkatachalaya himself has said that a short-term offender, an under trial prisoner, goes inside as a ordinary fellow and ordinary graduate and comes out of the jail as a postgraduate. And it is a fact. When we don't have any classification and segregation system being implemented scientifically in our prisons, naturally this kind of contamination takes place. So the one remedy is to seek that, implement more and more alternatives, see that people who don't deserve come to jail. Yes, sir?
Let us focus on this. Apart from, using of imposing fines, etc., and are there any other ways of reducing under trials? Now, I would like to ask you, I think we would keep it to a later discussion.
Right,
now,
sir.
Can I request Dr. Ranbir Singh to make his presentation? And we would like to really, we're eagerly awaiting your presentation, particularly in the context of your chairing a committee on reforms just now. And all these, any recommendations that come out of the present seminar will be extremely useful for you in your deliberations and in your recommendations. Dr. Ranbir Singh.
Can you hear me?
Yeah.
Yes, now we can.
Okay. Respected Ram Mohan Rao Garu and other learned speakers, I'm thankful to FDR and their team under the leadership of Dr. Jayaprakash for remembering me and giving me the privilege to participate in this very, very timely and very relevant conference on rule of law. My legitimacy, Raman Rao Garu, to speak on this occasion is I was the member of the Solicitor of the Committee and also the Kamal Kumar Committee, and was very actively involved in the DNA profiling bill, which nobody is talking and still lying with the MHA. Reforms are long overdue. Let me briefly discuss with you that when we were in the Solicitor of the Committee, a Model Police Act was prepared and sent to the states. And because of the that case which was in the Supreme Court, and famously known as Prakash Singh's case, where the guidelines were laid down with the Supreme Court. And the Supreme Court said, we would like to know that how many recommendations of the Solicitor of the Committee has been implemented by the states. And it was found to everybody's surprise that more than 90% of the recommendations of the Model Police Act or of the Supreme Court were not taken care of by any of the states. Some efforts were made by Kerala, of course. So the Supreme Court again said that there is a need to look into the police reforms again, and the Kamal Kumar Committee was appointed. And we had Maribat Committee, we had Professor Menon Committee, Justice Verma's committee, of course, made some significant contribution on a particular topic. I will certainly qualify by saying that whatever I say would be absolutely personal, because I, for some time, was a member of the Reforms Committee till I was the Vice Chancellor of NLU Delhi. And I'm no longer a member of the committee, so I'm here to speak to you. Otherwise, I would have taken excuse and not spoken to you. So, but I still qualify that whatever views I express are absolutely my personal. And I fully understand your concerns that instead of discussing other areas, there is a need to discuss the major thrust areas of reform, probably, especially in the field of criminal procedure, which I'm supposed to deal. And I would bullet those points so that we can concentrate on those points and also discuss as to what is relevant or not relevant. So there, we need to reduce large-scale criminalization of the society. Of late, we are adding more and more crimes, and our society is being criminalized. And we are one country where even poverty is criminalized. So we know that we have laws like that. And probably by reducing the number of arrests, approximately 75 lakh people are arrested every year by police in India under different laws. This is a very, very serious problem, and it leads to all kinds of problems like overcrowding in our prisons. I don't understand why we have laws which criminalize the society in such a big way. We need to. We recently discussed that there's a need to reduce the overcrowding of prisons by under trial prisoners by reworking on the bail provisions. Probably that is very, very important. 66% of the prison inmates are under trials, as you also mentioned, sir. We need to ensure that the criminal procedure conform to international human rights. So the IPC, CRPC came at a time when these democratic norms and UDHR were not there. We probably need to synchronize them with the human rights standards and also with the standards laid down by different constitutions. We also need to ensure speedy justice by reclassifying the offenses and simplifying the trial. There's a need to simplify the trial procedure. More than 70% of crimes are of petty nature and require no elaborate procedure of trial. Probably if we would concentrate on this aspect, it will provide us some breathing space. We need to assimilate the principles of alternative dispute resolution. Wherever possible, ADR is a kind of a mechanism which can be used even in criminal procedure by redesigning the provisions relating to compounding of offenses and plea bargaining, which was advocated by Malimat Committee but miserably failed, unfortunately. We need to look into all those reasons why the doctrine of the concept of plea bargaining did not work in India, is working very well in other countries, why it failed. So the existing provisions in this regard remain on papers only with no practical utility. As you also mentioned, sir, that very, very good recommendations of Malimat Committee, of Menon Committee, the reports of the Law Commission of India on IPC, CRPC, evidence and other laws is gathering dust. There is a need to call out all those important recommendations and wherever possible to implement. There is also a necessity to facilitate and simplify the procedure of reporting of crime by using technology. Why can't we use, there's a very strong interface between law and technology now, and many countries are using that interface for a speedy justice and speedy trial and speedy disposal of cases. Why that can't be tried in India? And so crime, by using technology and bringing in transparency and accountability in the procedures relating to registration of crimes is another area where we need to seriously look into. We need to guarantee complete justice to the victim. We have ignored one area. We have not looked at the victim justice the way we should have looked. Probably victim jurisprudence is a casualty as far as India is concerned. So we need to create mechanisms where we guarantee complete justice to the victim of crime by inventing tools for their long-term and short-term rehabilitation, including victim compensation and security needs. We need to ensure gender justice and gender inequality and removing bias of different kinds from the criminal procedure. Introduce witness protection. We so far do not have a witness protection law, and we don't have programs, we don't have procedures, and we found many of our cases fail because the witnesses do not come forward because there is no protection as far as the witness protection is concerned. Many advanced countries, we find that witness protection laws are very, very effective and they work very well. We need to reduce the workload from the judiciary by linking the number of criminal court with the reporting of number of crimes and establishing criminal court and civil court separately in a jurisdiction, including establishing more than one criminal court in a police station jurisdiction if need be. Especially in criminal cases, I do not understand that when a criminal trial takes place and the district session judge, he does so much of hard work and the trial is concluded, you then for confirmation, if there is a harsher penalty, it goes to the High Court and then to the Supreme Court. Probably this process need a fresh look. That why every case should be allowed to go to the High Court and the Supreme Court, and it causes a lot of delay in criminal matters. And when any criminal would know that the case would conclude in 15, 20, 30, 40, 50 years, the fear of law is gone. And the system, as far as the courts are concerned, because of the delay, the system by the criminals is being misused because the multiple system of appeals is creating a problem in the criminal justice system. We need to improve the quality of investigation. We don't, so far we have not seriously taken the training part of the investigating agency or the police. I remember in the Solid Swarajya Committee, we very strongly recommended that the law and order and the investigation too should be very seriously looked into, and there should be a separate training wing. And on that front, nothing has happened.
Sorry for an interruption.
Yes, sir.
Dr. Ranbir Singh, I know appeals, the right to appeal to various courts and all is delaying justice. But let us concentrate on how the trial procedure can be expedited. That is the most important thing. Unless we expedite the trial procedure and ensure that at the trial stage cases are disposed of within a few months or at the most 1 year, we cannot really speed up criminal justice. I would request you to
Ramon Rao Garu, one thing I do not understand, that when in most of the jurisdictions outside India, there is a time framework for decision of the cases. Why it cannot be done in India, where we have so much of backlog? And probably we need to seriously look into this. One attempt I remember was made where in CPC a provision was made that even the Supreme Court for deciding a case would decide within a time framework. But unfortunately, that was watered down by the Supreme Court itself.
In fact, you have laid time schedules on the police, particularly in cases where accused are arrested. The charge sheet has to be presented to the court within 90 days. Otherwise, the accused will be released on bail. Yeah. So the police have time schedules. How is it there are no time schedules in trial courts?
I definitely agree with you that we need to work out a time schedule for decision of cases at all levels, not only at trial court level, even at the High Court level, and also at the Supreme Court level. Since the bulk of cases are at the trial court level, I definitely agree with you that we need to seriously work on this. This
Another
will
point I would like to raise is that the Supreme Court has made observations a number of times that bail rather than jail should be the rule.
Yeah.
And if that is so, why are there so many under trial prisoners? Now, one explanation I can give, which I checked with Dr. Ahmed and he concurred with me. One of the reasons is that we have 28% of the under trial prisoners, 28 or 30% of the under trial prisoners are those who have committed offenses of property. Now, people who commit offenses of property are itinerant criminals.
Yeah.
They don't have a permanent station or residence. And if you don't put them in jail, there is no way you can bring them to the court to try their cases against them.
Yeah.
If you release, in fact, you cannot release them on bail because nobody offers surety for them.
Very right. Yeah.
And even if somebody comes forward and offers surety for them and is released on bail, he will immediately disappear from the scene and he will never come to the court. The case will remain pending. Therefore, that is the most important reason why most criminals who are accused of property offenses are under trial prisoners. But 62 or 63% of the under trial prisoners are those who committed offenses against body, against person. And if bail is the rule and not jail, why are all these people kept in jail? I can't understand.
Yeah. We need
can we make some recommendations in this regard?
Certainly, we certainly look into this. But one, probably I will leave it that. Another area where we really has faulted us, we need to facilitate and ensure quick attendance of the suspects and witnesses before the police during investigation and before court. And we have very greatly faulted in these areas. And if I go back to your question, this leads to enormous delays. And we need to have...
It's more than production of witnesses before the investigating officer. More than that, witnesses before court is the reason for delay.
Very right, sir. Very right.
Because I can't think of any police investigation in even the most important cases which lasts beyond a year.
You're very right.
Whereas cases lie in courts for trial for decades.
Yeah. And another area probably where we need to seriously discuss is public are not truthful before the courts. And there is no fear. There is no fear. One can easily lie.
Malimat committee has recommended on perjury, make a set of recommendations on perjury.
Yeah. We need to seriously look into that.
Yes. And also he recommended that we should change over from an adversarial form of trial to a combination of adversarial and inquisitorial form. For if a prima facie case is made out, we should switch over to the inquisitorial, and then a greater responsibility will lie on the judge with regard to investigation, with regard to the quest for truth, in the course of which perjury will also come into play.
Yeah, that's why where we strongly agree. You also mentioned, sir, that why not the important recommendations of the Malimat Committee or the recommendations by the Law Commission of India can be implemented. And such a wonderful work has been done by various committees and commissions. Probably
Malimat Committee has not touched on the court procedure.
Yeah, they have not.
Now, I would like to pose to you a question so that you can enlighten us and all those who are attending this conference. Now, appearance of accused in the court is a must for commencement of trial. Now, when the accused is represented by a lawyer, why is this necessary? Willful absence of accused in court for one reason or the other, in order to prolong and protract and prognosticate the trial, Do you have any remedy, any recommendation for that?
Whenever I had the occasion to visit many countries during my long tenure of more than 20 years as a Vice Chancellor, I also had the chance to visit many of the very senior courts. I found that the scientific method of identification of suspects and investigation has proved very effective in speedy disposal of cases.
No, I'm not touching on that. I'm touching on the fact that accused are released on bail, and on the scheduled dates of hearing, for one excuse or the other, they don't appear in court. As a result of which we get cases adjourned for years for appearance of accused in court. Now, is there a remedy?
Remedy is that we need to seriously tackle the problem of adjournments, which is at all levels, which is at the level of the advocate, which is at the level of the courts, and which is at the level of the system. Probably one very important aspect which have been touched by you, sir, is adjournments. And second, I would say is the system of appeals. The system of multiple appeals has also created havoc for this.
Later, but when the trial itself takes years, when the trial itself takes years, there's no point in talking about appeals. Now, in this regard, I want to pose another question, that when an accused is represented by an advocate in court, can we dispense with the appearance of the accused?
We can. Why not?
But why is it not being done? Can we suggest a reform in this regard?
We can certainly seriously look into this. This can be.
That will speed up procedures.
Yeah, it can be certainly looked into. So that's why I said some of the best practices in other countries can be certainly looked into for taking many reforms in criminal justice administration. That's where I also mentioned about the scientific methods. If there are so many technologies available now, like artificial intelligence. We started applying now.
No, but let us make the basic reforms. You're going into the next generation reform. Let us
I understand.
First attempt the basic reforms.
Very right. The trial court is very central to the criminal justice reforms. I certainly agree with you. But at the same time, there are crimes like cybercrime, the social media crimes, related offenses, which are now multiplying, and they are preparing another pitch in criminal justice administration and procedures. And we have found that separate police stations are being established or need to be established for these crimes, where experts from those fields should be different kind of IOs or the investigation officers, because the ordinary investigation officers will not be able to deal with these crimes. Especially cybercrime would be a very fertile area of encouraging criminal litigation in times to come. That has to be seen.
But the present pendency in courts is not on account of cyber crimes. It is on account of ordinary crimes.
Yeah,
and these are mounting. Therefore, let us concentrate on the trial procedure and see which are the areas where reform is imperative and urgent.
I think probably we need to simplify procedures. There need to be witness protection, and the system
witness
of
protection casts an additional responsibility on the police.
Police responsibility.
But I would like to submit that cases are not delayed on account of lack of witness protection. Witnesses come to courts, but still cases are adjourned time after time.
There I may slightly disagree with you, sir, because when you don't have an effective system of witness protection, why any witness should come forward in a court of law? Because that
No,
would certainly thereby delay the...
I can vouchsafe from experience that witnesses are produced in courts, but cases are adjourned for want of time, and witnesses are made to repeatedly come to court. Therefore, they lose interest. They lose interest in cases. And it is not so much on account of lack of protection as the dilatory procedure that makes witnesses reluctant to give evidence.
And the way we treat witnesses is also a serious concern for me. Somebody who comes to help the court and will keep sitting there for a whole day, and I certainly agree with you that the case is adjourned, and expert witness, they face all kinds of problems, or one pretext or another, they try to avoid coming to the courts. And all these systems, all these mechanisms which need to be changed aggravate the delay.
One question I would like to put to Dr. M.R. Ahmed, in fact, I would like to raise, in fact, he had been telling me informally. I believe that, in the old system, we had a sub-jail attached to each taluka court. We had only one magistrate's court for each taluk, and each magistrate's court had a sub-jail attached to it. Therefore, the under-trial prisoners used to be parked in the sub-jail.
Yes.
And it was a matter of moving them from the sub-jail to the adjacent courtroom for hearing of trials.
Yes, sir.
But I believe this practice has been done away with. Now, no new sub-jails have been formed. On the other hand, most of the under-trial prisoners are also parked in central jails. And this makes production of under-trials in courts a more dilatory and difficult exercise.
Yeah.
Can we recommend going back to sub-jails?
Number one, sir. Okay.
I would like Dr. Ahmed to react.
Ahmed, sir. Ahmed, sir. This is your subject.
First of all, sir, sub-jails are not closed. Only sub-jails where the population of prisoners, where the number of prisoners is too low, it was impractical to run those sub-jails. That's one point. Second thing is, there is a heavy shortage of staff in central jails and district jails. So administratively, it was felt convenient to divert the staff that are working in sub-jails to the nearest district jail, along with the prisoners also. And if the prisoners are shifted in the same district, rather than being shifted to central jails which are far away, it was felt that the inconvenience is not much and the production can be ensured. And the third thing is, with the introduction of video linkage between courts and prisons, except the trials, the normal extension of remand was being done without actually being prisoners being produced. So it actually did not affect the prison administration, or for that matter, the courts.
Courts have increased. Courts have proliferated.
Yes.
On the other hand, jails have become concentrated. No, the reform has gone in opposite directions. Now, you see, even if the under trials are kept in the district jail, they have to travel 60, 70, 80, 100 kilometers to go to a magistrate's court in sometimes.
Only for trial cases. Only in trial
cases. That's why the under trial prisoners are more in central and district jails. Now, if you have sub jails, now this problem is solved, because there is a corresponding shortage of police. Now you need more policemen to go to the central jail, district jail, and bring the under trial prisoners all the way to the various courts, magistrates' courts.
No, that's not how it happened.
This is a satisfactory reform.
No, sir. That is not how it happened. If in a district there are 7 or 8 sub-jails, and the number of prisoners in each sub-jail is so low, sometimes 1, sometimes 2, sometimes 3, so it was felt practical to shift that 1 or 2 prisoners to the nearby sub-jail, which is again another 10, 20, 30, 40 kilometers away.
But there is a dichotomy.
Not to central jail, sir.
No, when the under trial prisoners is on the increase, how can there be fewer prisoners in the sub-jail? They can be distributed among the sub-jails.
No, sir.
The under trial prisoners, instead of being concentrated in the district jail, can be distributed to the sub-jails. I think, see, decentralization of governance is one of the key issues of good governance.
Yes.
Now, in prison administration, instead of decentralization, you are centralizing prison administration.
And you don't have.
I think Dr. JP should
not all sub-jails are
deliberation.
No, sir. Not all sub-jails are closed. In a district, 1 or 2 sub-jails are closed on account of shortage of staff, on account of...
Apart from closure of sub-jails, I am saying distribute the prisoners who are in district jails into the sub-jails so that
we need staff also, sir.
Distances can be covered to go to the court.
We need staff also. Unfortunately, there is a shortage of staff.
Dr. Ahmed, the issue is lack of funds and staff, as you rightly put it.
Staff is not there, funds.
And lack of funds also.
This is a point for further discussion. For any other points?
If you permit me, sir.
Now, Garu,
I'll ask Dr. JP to intervene.
Yeah, please.
1 minute, Dr. Ranbir Singh. I want you to respond. As far as the question you raised, sir, we will go into data along with Dr. Ahmed and see what is the best way out. Because ultimately, if you look at Indian prison population, for a country of our size, we have one of the smallest prison populations. I feel good about it, actually.
Yeah.
But perhaps we have too small a prison population, apart from the under-trial problem. You know, US has about 2 million prisoners.
Yeah.
For a population of 330 million, we have only 400,000. If you actually take away the under-trials, it will be 100,000 plus.
While the number of prisoners is low, the proportion of under-trial prisoners is high.
Exactly.
High.
Now,
Yes.
therefore, what I am suggesting is, if the under-trial prisoners are distributed among the sub-jails, the trial of criminal cases can be expedited. So instead of moving an under-trial prisoner over 100 kilometers, 110 kilometers, you can move the prisoner 10 kilometers, 12 kilometers to ensure that he is present in the court on the date of hearing. So
no, but it amounts to the same, sir. If you shift prisoners from district jail to sub-jail, it doesn't make any progress, because the question is, if the sub-jails, yes, minor offenders who are likely to get a sentence of 1 month only are supposed to be kept there. The moment a person involved in a dacoity case or robbery case, he can't be kept in sub-jail. That is the rule. So he has to be shifted to the nearest district jail. And in the district jail, there is enough security to keep him under custody. And since till the trial doesn't start, he will be produced through video linkage. And once the trial starts...
We take your point, we'll put it for further deliberation.
Yes, sir. Yes.
If I may ask Dr. Ranbir Singh, sir, for the intervention.
Yes, sir.
Another thing, Dr. Ranbir Singh, I would like to raise from my personal experience is about separation of trials and joinder of trials.
Yeah.
Suppose there are half a dozen accused and 2 of them go underground. Now the police wait for a year or 2 in order to nab these 2 underground accused. And if the police fail, they approach the court for separating the case of those 2 from the other 4 who are attending the court regularly. Now what happens is, as the trial proceeds, after a number of witnesses are examined, the underground fellows appear in court and call for the recall of witnesses.
Mm-hmm.
And when the witnesses are recalled, their second testimony will always have some discrepancies from the first testimony. And the discrepancies are used to assail the veracity and the truthfulness of the witness. Now, in regard to willful absence from court of accused, can we complete the trial and also pronounce a sentence so that they are not given an opportunity to frustrate criminal justice?
And this can be treated as a serious offense when somebody willfully does so.
Yeah.
And why should people like this should be allowed to play with the administration of justice? I definitely agree with you. That is certainly possible. Why not?
Dr. JP has a point.
Yeah,
Dr.
please, sir.
Singh, this
Yes,
is an appeal to you in your capacity as the former chairman of this committee. I would like you to use your good office. So there are three broad things. One is procedural reform. The other is the structural reform to make prosecution and investigation independent but accountable.
Yeah.
At least serious crimes, even if petty crimes, it's not feasible for a variety of reasons. And the third is infrastructure, technology, and forensics.
Yeah.
If we segregate these three and look into specifics, I think a lot of productive outcomes are possible in a broadly acceptable way. What we're trying to do in this conference, as you noticed, is bring all the stakeholders together and find a balance, not an ideal solution, but a pragmatic solution we can all live with.
Pragmatic, incremental.
So I don't know if the committee is open to interaction with eminent experts across the country. If you could use your good offices, we'll be happy to bring some of the finest minds in the police and judiciary, including Supreme Court judges and others.
What
their opinions. A lot of people.
What Dr. Jayaprakash we discussed initially was that they will certainly be discussing with different stakeholders once the findings are finalized. Let's hope it happens, because discussion and debate is very, very important. One point I would like to make here is another weakest link with us is the Office of the Public Prosecutor.
Absolutely.
Where we have very badly faulted, and we have never recruited best of skilled people as public prosecutors. And that is
yesterday, I think, in another session, wasn't it?
Yeah, but that is also closely connected with everything, even trial, even investigation, everything, and that has created great damage to the system, as far as I know. So I would conclude by saying that reforming criminal procedure is a of course, very wide and painstaking exercise. It, as Dr. Jayaprakash mentioned, it requires association of all stakeholders on a regular basis in the continuous process of deliberations and drafting the reforms. It should not be undertaken in a haste. I agree with you, Dr. Jayaprakash, and it is a time-consuming process. But at the same time, time has come where we need to seriously look into these reforms. Tomorrow would be too late. Today is the time to look into all this. Thank you very much for giving me time and
Thank
giving
you,
me this
Dr.
privilege
Ranbir Singh. Thank you very much. Now, I would like to make an observation in this regard. Now, Justice Malimat Committee doesn't seem to have made any recommendations with regard to plea bargain.
Okay.
As far as I remember, I've read the Malimat Committee recommendations. I don't recall any mention of plea bargain.
I have to relook into that.
Compounding, yes, but not plea bargain. Now, plea bargain doesn't have anything to do with the trial procedure, because once plea bargain is done, the case is closed. Cases which are tried, how do we expedite them and make them speedier? That is the point.
One caveat, sir. I have been always a great fan of plea bargaining, but after seeing some of the American experience, I think some amount of safeguards are required, because what's happening is without legal representation. The prosecutor in America is very powerful. As you know, conviction rate is 98%, 95%. It threatens them with a higher offense, charging with a higher offense with much greater sentencing, or gives them an option to agree to a smaller offense and then smaller sentence, even if he's innocent. In India, I suppose conviction rate is so low that may not be a serious problem. But some safeguards are necessary so that the poor, for want of representation, are denied an opportunity to defend themselves. That's my only plea.
Very right. Very right. Very right.
Now, let us open the seminar for questions and answers by the participants, those who are not on the panel, but the public who are probably witnessing this discussion, this conversation. I would like to throw open this discussion to the public.
In the chat. Please go ahead.
Yes, sir. Sir, we would like to start off with a question for Dr. M.R. Ahmed. So, sir, Section 436A of the CRPC provides for way out to release under trials those who have served more than half of the maximum sentence that can be awarded to them. Sir, in your experience, is this provision utilized optimally, or if not, what can we do, or what modifications are required to ensure that this is used?
No. As far as prison authorities are concerned, Section 436A has not made any difference. The number of under trial prisoners continue to rise. I think there are other measures that are required. Now, there are under trial review committee meetings. There are high-level review committee at every state level, especially Telangana and Andhra. The under trial review committee, which meets every quarterly, looks into cases of under trial prisoners who are there in the jail for more than 3 months. So they are taking action. Now, as far as those cases where prisoners are involved in multiple cases and heinous offences, now 436A doesn't give permission for releasing them on bail. I mean, dangerous offenders and those who are involved in multiple cases and different. So the court can always reject granting bail to them. So of late, I mean, you find that as far as people who are there for 3 months or 4 months who are non-heinous, courts are releasing them. But in the other cases, there are. I mean, in fact, I have got some figures also. Of course, the number of such people who are staying for more than 5 years or more than 2-3 years is not very high. But it is due to the continuous inflow of prisoners. That is what makes. The figures that are given in the statistics only reflect on a particular date, not the figures which start from January 1st and continuously they come to jail till December 31st. In the process, some will be released, some will be coming, some will be again coming. So that is how the figure comes. It doesn't reflect in the realistic manner.
So as a follow-up to that, we have a question. So one of our panelists from the other session who's attending this session is asking, is this because typically the under trials are accused of a number of sections and they have multiple cases against them? Does that have
Not all of them. Maybe about 5-6% of under trial population may be having more than one case.
Okay.
Not all. I mean, such people, naturally, they will be not considered for bail if they are involved in heinous offences like dacoity or robbery or extortion or something like that.
They will be mostly offenders against property.
Yes.
That is thieves and robbers and dacoits.
Yes.
Not offenders against.
And offenders against human body, they are considered to be quite safe for release on bail because they are not property offenders and they are not likely to commit any other offence. It's a personal sort of under provocation, fit of anger. So that's why our open prisons are successfully running in spite of people. Open jails are crowded with lifers. Majority, 90% of prisoners are life convicts, but still there are no escapes.
Okay, sir.
We don't take property offenders in open prisons.
Okay. Sir, I would like to bring in Dr. Ranbir Singh here. Sir, you mentioned how bail provisions need to be changed in order to address this problem. Sir, what changes do you envisage in this regard?
No, my point was the bail provision, bail jurisprudence is being misused. So there is a need to seriously look into the whole gamut of from time to time the various courts. High courts and Supreme Court has also given a number of recommendations as to how the misuse of bails can be, and there are also reports by the Law Commission where this issue has been tackled probably. So bail is one area where it is the whole system of criminal justice system is being misused by the offenders probably. We need to seriously look at that.
So could you elaborate on how it is being misused?
I mean, I have my reservations because I said many of the being sometime for the member of the committee, I would like to refrain from getting into nitty-gritty of many recommendations. You will excuse me for this. So
I can answer that.
Please, yeah.
You see, an accused released on bail absconds from court. He doesn't appear in court on the dates of hearing for trial. And that delays the trial itself for years on. In fact, that is the point I've been making all along. That can we bring about a fundamental provision in criminal procedure that trials can be continued in the absence of accused. If the accused is willfully absent in court, can we go ahead with the trial and complete it and adjudicate his guilt? Because he is represented by a lawyer in any case. And even if he has no lawyer engaged by himself, he has an amicus curiae.
Yeah.
Over to you.
Therefore, there is no reason why an accused should be physically present in court for conducting the trial. In civil procedure, it is not necessary.
Yeah.
So this is a fundamental reform which has to come, particularly in regard to terrorist cases and the Naxalite cases.
Very right.
We cannot bring any Naxalite to trial. And that is the reason why those 4 people are kept in jail as under trials.
Yeah.
Samantha?
Yes, yes.
You.
I would like to leave. I have to attend another meeting, please.
Sure.
If you,
Sir,
If you have
one
any
final
question or
question.
two of Dr. Ranbir Singh, ask him, otherwise we'll let him go.
Any
Yes, sir.
questions, Dr. Ranbir Singh?
Yes, sir. One final question.
To Ranbir Singh.
Yes, sir.
Yeah,
Oh, sir,
he's gone.
he left. Okay, sir. Okay.
What is that question?
Sir, he mentioned how alternative dispute resolution, a concept of that could be adopted to the criminal justice system as well, and how compounding of offenses can be modified and in a way brought in tune with today's needs. We wanted to know how he envisaged that as well.
Compounding and alternative dispute resolution systems are, I think, more relevant and applicable to economic offenses and the like. But in regard to offenses against body, for instance, in a case of murder, or in a case of rioting, or in a case of unlawful assembly where enormous damage has been created to dealt to public property, I don't think there is much scope for alternative dispute resolution or compounding.
Okay.
Riots, where people are massacred, communal riots, murders. Now, rioting in villages where, opposite factions come to clash and break the bones of each other, one another. I am not sure whether there is any case of alternative dispute resolution there. And these are the people who are in jail as under trials, in prison. Not the economic offenders. Economic offenders are now in prison because they're running they are not in prison in India. They have run away to other countries, economic offenders. Now probably we'll come to a stage where economic offenders will also have to be put in prison during trial. Now, alternative dispute resolution essentially relates to cases of an economic nature, financial nature, rather than, contracts and things like that, cheating perhaps.
Raman Rao Garu, the next question is directed to you. In your experience as a police officer, how would you strike the balance between protecting the rights of the accused and at the same time ensuring justice is delivered? The specific context for this is the Parliament recommendation of allowing confessions to police officers of the rank of superintendent of police and above. So how would you ensure that this provision is not misused?
The balance is disturbed because there is a fundamental and almost total distrust of the police. Now, that is the reason why people are not prepared to accept confessions before police officers. But there are other para-police organizations, for instance, forests. Now, if you argue that police are oppressive, they indulge in use of force, they don't treat the offenders well, I think it equally applies to the forest officers. Forest officers don't treat people who encroach into forests and who take forest produce kindly. But confessions before a forest officer is admissible in court. Similarly, a confession before a railway protection force officer is admissible in court. So there is no reason why there should be such complete mistrust of the police. As a first step, they have recommended that confessions before police officers of a particular rank and above can be admissible. So that, you take the first step, and thereafter if police behave well, probably confessions before inspectors and sub-inspectors can also be made admissible. But in this regard, I would like to bring one feature to your notice. Now we have video recording. Now, if a confession is recorded by video, at least that should be admissible. Now, all interrogation of witnesses, all interrogation of accused can be mandated to be done only under video. That is possible. And if that is possible, and the video examination of witnesses and video recording of the statements of witnesses and statements of accused is permitted, then the next step should be to accept confessions before police officers as evidence in court. And now in this regard, I would like to bring some of my personal experience to your notice. Now, there is a general belief that police torture people. Now, to my knowledge, I have personally investigated about 50 murder cases and supervised the investigation of about 150 murder cases. Many other police officers have done much more because I've gone into other fields of policing rather early. Now, in all my experience, we have never tortured a witness. We have probably threatened a witness. We have various methods of threatening a witness and extracting the facts out of it. Because if you straight away go to a witness and say, please tell me what happened, he will never tell you. No witness, in my knowledge, has ever come forward to narrate what has happened. You have to sort of put some pressure on him, but that is not torture. Torture is basically applied to property offenders to extract information on where he has sold the property or where he has secreted the property. It is also applied on accused of murder cases to get the information out of him as to, for instance, a murder has been committed with a knife. He would have thrown the knife somewhere or he would have secreted the knife somewhere. Now, if torture is applied to him, to know where he has secreted the knife or where he has thrown it, recovery of a piece of material evidence by interrogation. By sheer interrogation, he will never tell you. But he will tell you these are the exceptional cases of torture. But there is a general belief that police torture everybody. It is not true. And torture is also sort of imposed on the police in these exceptional cases because you don't give enough time to the police to investigate a case. For instance, under the Criminal Procedure Code, if an accused in a murder is arrested, he has to be produced in court within 24 hours of the arrest. Now, 24 hours is not sufficient for interrogating an accused and extracting information out of him. Now, if we are put under pressure of time, under pressure of time schedules, extra legal methods are resorted to. For instance, public pressure on murders for gain. I know one case personally, long years ago. There was a murder for gain in Guntur district. And for next 4-5 days, there was no clue as to the murder. And there was enormous public pressure. And when there was enormous public pressure, the investigating officer, who was an inspector, he caught hold of somebody and fixed him up in the case on suspicion. It's not that he fixed him up on sheer innocence. He had suspicion against him. He thought he could sort of satisfy the public by fixing up in this murder for gain. And 4 days later, we got the real culprit. Now, these are the difficulties that police face in investigation. Now, nobody understands these difficulties. Now, in my view, a very salutary recommendation should be that all magistrates and judges should investigate a few murder cases as part of their training. Then they will know the difficulties of investigation and how sometimes impossible it is to get at the truth in an investigation. Cases based on documentary evidence and all are very easy to investigate. But cases which are based entirely on human evidence are very, very difficult to investigate and get at the truth. 2 witnesses to a murder will first deny that they were present at the murder. Now, after a lot of pressure, they will say we were present at the murder, but the 2 witnesses' statements will be at odds with each other. And if a police record those statements as they are, the case is sure to fail in a court. So you have to do a lot of balancing of the 2 statements to arrive at the correct statement. And then if the witness is won over, he will give a different version in the court, and then the case gets acquitted. Now, these are the practical difficulties of investigation. Any other questions?
We have a question for Dr. M.R. Ahmed. Sir, you talked about alternatives to imprisonment. Sir, from your experience on researching prison systems in the other countries, what do you think is the best alternative to imprisonment, and also is at the same time effective in deterring crime?
Dr. Ahmed is the best to.
I'll answer with this very interesting example.
It's a very interesting thing, and they have done a lot of work on this.
Yeah. I mean, in Hyderabad and in many other places, drunken driving has become a menace. So what everyone is doing is that the police frequently checks at different points and catch hold of them, and many of them land up in prison. So many think that is the right thing to deter them from drinking again. But this kind of situation in Indonesia some time back has gone to such a serious proportions. The number of such offenders has gone up so high, then the jail authorities, the police and the local people, everybody started thinking there has to be some other method. So then they came up with a new method, alternative to drunken driving, in the form of community service, with a condition that all such offenders should work in a trauma ward of the hospital, where accident victims die or they undergo injury or bandaging, etc. And in a matter of couple of months, the offenders who had seen that, and then when they go out and they express the trauma which they themselves undergo, that brought down the number of offences in Indonesian jails. Now, the best alternative to imprisonment or non-custodial measures is which has been implemented in Scandinavian countries, and you'll be surprised to know that in Netherlands the jails have become vacant. Totally, and in fact they are taking the prisoners from other neighboring countries to utilize the jails they have. And in Sweden, Germany, they have brought in a wonderful reforms. The police, the politicians, and the civil society, they all came together. They said that jail cannot reform people. In fact, we are damaging by keeping them. So we have to have some other method. So they have started what is called day fine system. They have got community service, community attendance centers, and a different type of this thing. Of course, probation is given, and in some cases, periodical imprisonment. The prisoner goes to jail in the evening, comes out in the morning, goes to job, and again comes, reports back to the jail. So there are different innovative concepts are being utilized all over the world, and they are proven to be very, very innovative. And
Next question.
Yes, sir. Okay. Harshita, you had a question for Ram.
some technical.
Okay. Sorry. So we'll come back to Dr. Ahmed. So until then, over to you, Harshita. You muted Harshita.
Raman, this is actually a frequent question being sent by the participants. We've discussed so many recommendations, so many reforms. According to you, which one should we prioritize amongst the ones that we discussed today?
There are some incremental reforms. There are some basic reforms. Now, for instance, the Malimat Committee recommendation, we must take a decision on two aspects. Standard of proof. Whether the standard of proof is required, the standard of proof, as I had mentioned earlier, that is beyond all shadow of doubt of an ordinary prudent man, whether that is necessary for every offense. Now, in my view, the more serious offenses like murder, like rape, may require a very high standard of proof. But small little affrays, now for instance, outraging the modesty of a lady, these are minor offenses. These offenses, you don't need to have the same standard of proof. For in my view, reforms with regard to standard of proof and summary trials for smaller offenses probably is the first step that we should look at in terms of priority. Then the second one will be, in fact, outside the procedure, there are a lot of administrative reforms. Case management is the most important reform. Alignment of the jurisdiction of a court and police stations is a very important reform, which have been mentioned in our paper. Now, for instance, I know from personal experience that if the magistrate has 6 courts, has 6 police stations under his jurisdiction, every day he posts cases of all the 6 police stations. And nobody knows which case he is going to take up. Instead of that, if he allots a particular day to a particular police station, then it will enable the police station also to concentrate on production of witnesses. Now, unlike the court, police have multifarious duties. Court work is only one of the duties. For unless he knows on what day he has to attend the court, it will be difficult for him to produce the witnesses. Therefore, these are for instance, call work. The whole forenoon of a magistrate is wasted in calling cases. Now, this can be entrusted to an administrative clerk. So these are some of the reforms which we must bring before we think of the more seminal reforms on adversarial or whatever we have got.
Thank you, sir. So we are nearing the end of the session. So I would like all the panelists to kindly give brief concluding remarks. Maybe Dr. M.R. Ahmed can go first.
I would like to speak about, there's a lot to be done about the prisons. And it is not a consolation that the incarceration rate in India is hardly 35 for 1 lakh population. It is the question of principles and the question of how we treat our own citizens. And we should keep, in my personal opinion, as well as all criminologists all over the world, they agree that prisons should be used as a last resort and only for those people who are threat to society, who commit heinous offenses, and who there is no other place to keep them. And all these small offenders or minor offenders need not be sent to jail. And we need to look for non-custodial measures to keep them, to save them from dangerous effects of prisonization and stamping.
Thank you, sir. So we would also like to hear the thoughts of Dr. JP, who's joined the session.
Sumedha, I have nothing specific to add except that I've been following some of the comments in the chat box. Two broad things. One is still some people harbor this mistrust of police. Why only police? What about administrative officials outside the police? What about the courts? What about the prosecution? What about elected representatives? In a democracy, there's a fundamental principle. Empower, but hold them to account. Not mistrust from the beginning, weaken them, and then create a situation of law becoming irrelevant. That's what we have become in India as a country. So we have to see the balance of convenience. You take a sub-inspector of police. Under the law, he has the power to use any amount of force to disperse an unruly crowd, including firing. There may be an inquiry tomorrow. And you cannot trust the person. You do not want to trust the person with getting a confession. You have all the safeguards. But this absurd notion, because the white police officers in the pre-independence era generally thought that the black policemen were bad people. And policemen are only to control the indigenous native population. And that is where the whole mistrust is. Many of our mothers in our generation, not your generation, actually used to frighten children whenever they were recalcitrant, they were difficult or not eating food or something. Look, there's a policeman. Now, we have to come out of that. And it's not merely on the part of the police. Obviously, police have to improve many things that need to be improved. But we as a society must recognize that there is a balance. We are the ones who suffer. If you empower the police but hold them to account, that is the heart of the issue. I was in New South Wales as part of the Administrative Reforms Commission to look at the police functioning. The intricate mechanisms they created for accountability. Police are adequately empowered. Whether it's a prime minister or a premier of a province, a police can investigate and arrest. But there are a number of safeguards. So that is the art. Give power, adequate power to safeguard society, and yet ensure there is adequate accountability, because beyond a point, power can always be abused by everybody. Why not judges? It's not merely policemen. So this notion that policemen are the enemies of the people, some of us in the middle classes and intelligentsia, we harbor that. I think it's a counterproductive notion. It's not about taking the side of the police or taking the side of citizen. We are all on the same side. We have to build institutional mechanisms to empower, but hold them to account. And there are many other questions pertaining to a large number of other incidental reforms. For reasons of convenience, we had to compartmentalize the discussion in each session. It doesn't mean that's the only thing required. There's a whole lot of things required. But if we combine everything and jumble up, then nothing productive will happen. So be patient, and those who are interested, there are, I think, 10, 11 sessions, main sessions apart from the side sessions, which go into a great deal of detail. And some of you are talking about trial courts, Indian Judicial Service, etc. Many of these we attempt to address, though everything under the sun cannot be taken up at one go, however elaborate the conference is. But we will take on board all the suggestions and the concerns, and we will do our best. This is not merely an event management. This is not about simply talking and then finishing an event. It is about serious advocacy. That's why a quality paper is produced by our team, and we will improve that constantly. We will take into account some of the comments by the panelists and experts, and the work being done by, not only the work done by the commissions earlier, but the work being done by the committee appointed by the Government of India today. And we'll see how best to engage with them in a transparent manner, to get the best outcome with adequate safeguards. Thank you.
Thank you, sir. And may I now request the Chair, Shri P.S. Ram Mohan Rao Garu, to conclude the session.
I thank all the panelists for the valuable contributions that they have made. Now, this is a very complex subject. And as Dr. JP has mentioned, this is not the end. In fact, this is a part of a very prolonged process. And it is, it may be too much to expect that the results will come out of this exercise at once. It will take a long time, but our endeavor should continue. And we should ensure over a period of time that an outdated justice system is brought update and reflecting the current realities and the current aspirations of the people. With these remarks, I think I thank all the panelists and also all those who have attended this video seminar. Thank you.
Thank you, sir.
Thank you, sir. With pleasure.
Harshita, closing remarks.
Yes.
Vote of thanks and conclude.
Thank you everyone for tuning in, and a very special thanks to all the speakers for an enriching discussion. Our apologies for not being able to take up all the questions that were sent to us due to paucity of time. If your question was not answered, or if you have any other questions, please feel free to email them to us at contact@indiandemocracyatwork.in. The next session in the conference is a topical conversation on extraordinary laws to be held tomorrow from 7 p.m. to 8 p.m. Join us to interact with Professor Kham Khan Swan Housing, Professor Ujjwal Kumar Singh, and Shri Karnan Arvind Rao. Thank you and hope you have a great rest of the evening.